Guyana will become the next Dubai, and we, the citizens of Guyana, are super excited to benefit from our homeland the same way the citizens of Dubai benefit from theirs.
This is what life is like for citizens from the
Guyana will become the next Dubai.
With wonderful people all over this country. She is a beauty, beautiful Guyana.
Good night to all our listeners. You're listening to Globespan Television. This program has been made possible by Mr. Nohar Singh, and our technical directors are Mr. Devin Bissoon and Mr. Ryan Gobin. We are streaming live on Facebook and YouTube, so you can tune in there to get to listen to our program. Tonight we have a familiar face with us. He is someone who has been very and heavily involved in the border dispute with Venezuela. He is Guyana's ICJ agent, and he is no other than Mr. Carl Greenidge. Mr. Greenidge, welcome to the program.
Good evening, Dr. Rose, and good evening to all your viewers and listeners.
Mr. Greenidge, I have a number of requests today to ask you this question, and that is, what led to the 1966 agreement after the 1899 agreement granted Guyana exclusive right to its territory? This is what a number of our listeners are asking. What led to the 1966 Geneva Agreement after everything was completed in 1899? Can you explain that to our listeners, please?
Yes, certainly. In 1966, the British government and then the Guyana government concluded an agreement with the government of Venezuela, which agreement was intended to deal with a contention by the Venezuelans, a contention which arose in 1962 as Guyana was negotiating the last stages of its independence from Britain, as required by the UN. And that agreement, in essence, said, look, Venezuela has alleged that the 1899 award is invalid. And you will be aware, Dr. Rose, that having said that, Venezuela undertook a variety of actions that many people regarded as prejudicial to Guyana's independence and its survival as an independent state. And therefore, it was agreed that provision would be made to allow Venezuela to consult with the relevant archives and institutions of Britain and Guyana, if necessary, to see the documentation and to satisfy themselves that the arrangements that were concluded in 1899 were in order and above board. That was what was agreed. The Geneva Agreement itself, in its title, explains that. In the preamble, it does say, as Venezuela keeps insisting, that there be bilateral discussions in order to satisfy the two sides that all was above board. And the agreement itself set out, in the event that the two parties couldn't agree at the end of the very first phase, which I will call the first phase, that is, there was a joint commission established, and that joint commission sat for a specified period, defined and agreed by the two sides, and the agreement provided that in the event that that joint commission failed or arrived at no agreement, that the two sides would go through agreed steps. Which steps are those set out in Article 33 of the UN Convention? All the various actions that could be undertaken to resolve the matter were there. It made no provision for any transfer of land. It made no provision for, in fact, the agreement makes no mention of Essequibo. I like to make that clear because I think Venezuela has itself conveniently referred to the agreement and then thrown in things that have nothing to do with or are not mentioned in the agreement when it contends that Guyana has failed to honor the agreement over the years. That is not so, and we have met all our obligations under the agreement. The agreement continued from 1966 until 2015, and in 2015, an additional leg was added, if you like, and that leg was one triggered by the UN Secretary General, bring the two sides together. After discussions, he decided, notwithstanding the fact that Guyana was calling for a movement to the court in keeping with the provisions of the agreement, the Secretary General decided that he should have one last try, one final year of bilaterals with the assistance of the UN, so that any doubts, any unexplored avenues could be explored to try and bring this rather grievous and tiresome matter to an end. And from 2015 to 2017, the Secretary General, first of all Ban Ki-moon, and then Mr. Gutierrez, worked on this matter with Venezuela and Guyana with the assistance of the Honorable Doug Newlander, a very close friend of Venezuela. And at the end of that exercise, after Venezuela's president had rejected 6 names as good officers to try and facilitate the exercise, discussions had been held, and the 2 Secretary Generals concluded that further discussions in that bilateral framework were unlikely to lead to any what he had agreed should be a closing of the gap. There was no closing of the gap. In fact, the gap was widened. And therefore, Mr. Gutierrez sent a letter to both presidents, as promised and agreed by the 2 sides, which said, look, we've had what is termed enhanced mediation, and the gap between the 2 countries has not been narrowed. And therefore, we will now recommend that the matter go to the International Court of Justice, which was a step, notwithstanding what Mr. Maduro says, it was a step agreed by Venezuela, both in the 1966 agreement, as well as during the discussions on the from 2015 to 2017 under the enhanced mediation. Okay, so in 1966, the action was taken to take from the 2 parties pressure that was dangerously high, notwithstanding all that Britain did. I've seen many people who have not been following this matter air all sorts of views that it was unnecessary, we could have gone forward. We could have gone forward, but what would have been the consequences? Nobody wanted to take the blame for going forward and finding ourselves in a situation where a larger neighbor was threatening, in essence, to overrun us and seize our territory. It is, I'm reminded, also similar to problems that Belize had as they approached their independence. And this was taking place notwithstanding the fact that Venezuela had agreed and honored the obligations arising from the 1899 agreement for over 63 years. That is as short as I can make it.
Okay. Again, folks, we are streaming live on Facebook and YouTube. And we have with us here Mr. Carl Greenidge. Our topic we're discussing actually the new threats made by Venezuela, the Maduro regime of Venezuela against Guyana and so forth. But Mr. Greenidge, can you tell us briefly what the 1966 Geneva Agreement entails? Give us the highlights of it, what it says exactly.
The agreement starts by pointing to the fact that Venezuela was contending that the 1899 award, which is an award by an international panel of, at the time, what was accepted as some of the world's most experienced and finest judges, had handed down after hearing over 6,000 arguments associated with over 6,000 pages of documents. Many, many hours of debate and argumentation over all different things raised by Venezuela, by Britain. It concluded and therefore made an award. And in essence, the award, in a nutshell, gave to Venezuela those areas which were at that time, 1899, 1897, under British control and which they seemed to think might satisfy Venezuela's concerns because it would allow Venezuela full control over the Orinoco and the Orinoco Delta. That is the essential principle of the decision taken. And they went so far as to, in the northwest corner of Guyana, to allow Venezuela to have a sliver of coastland. And when you look and ask, well, why would that territory, which was never controlled by Venezuela, be given to Venezuela by the arbitration panel? One can only conclude that that was intended to ensure Venezuela had the wherewithal in terms of the geography to control the estuary of the Orinoco, because a lot of the argument turned on the Orinoco. And contrary to what we see going on now, just as I say, there's no mention of the Essequibo in the Geneva Agreement. The focus of a lot of the debate, in addition to all the claims made by both Britain and Venezuela, was Venezuela and the United States concerned that a European country shouldn't be in a position to control such a critical international passage as the space between Trinidad and Tobago at the mouth of the estuary of the Orinoco. And that, as I see it, is what Venezuela got out of it. It didn't have that territory before. It didn't have control of the territory. And at the end of the award, or as a result of the award, that is what they had. And Guyana was given, as it had contended in any case, those areas that we now know. There is no other mechanism determining the borders between Guyana and Venezuela. That is the instrument, the 1899 agreement. So the contention often being made by Venezuela, which suggests that, well, the 1899 award was invalid, therefore we can have, is nonsense. There is no agreement that would redefine that border. The two countries would have to come to some kind of an agreement, either of their own volition, which clearly they haven't managed to do after so many years, or with the intervention of an internationally accepted body, whether it is the Law of the Sea, the use of Law of the Sea Convention or any other body, so that an agreement can be arrived at. But having agreed one set of boundaries, one has to be concerned as to invitations now to revisit this. Where will we go from there? And this absolutely is one of the dimensions that Venezuela seems to find convenient to ignore. If you can have neighbors with whom you have boundaries, you've agreed either of your own volition or with third parties, you've agreed borders and boundaries, and none of your neighbors, with the sole exception of Venezuela, can you keep your promise to recognize those new boundaries? Something is wrong. And that is where we are.
Okay. Now, the International Court of Justice has ruled recently. It's a preliminary ruling in favor of Guyana. Can you explain to our listeners what that ruling was all about?
Well, the court received from Guyana's complaint, and this was in keeping with the decision of the Secretary General to send the matter to the court, or to have Guyana take the matter to the court. And Guyana therefore prepared its memorial, setting out its concerns. And essentially they're what I said. The country has a neighbor. The neighbor had agreed to borders, respected the borders for 63 years, and then decided one morning that those borders are no longer to be respected because for some reason it has unilaterally decided that the agreement of 1899 is invalid. And so when the two parties sat down with the Geneva Agreement, the purpose of the Geneva Agreement was to make provision for them to examine the information. If the agreement is invalid, it has to be invalid based upon some objective factors. Are those objective factors to be found in the documentation that is available to us from the two parties, namely from Britain and from Venezuela? Since it is Venezuela that was making the contention, two technical committees were set up, and those technical committees were set up to explore documents. And in fact, because it was Venezuela making the complaint, making the allegation, the documents that were examined were largely British documents. They examined those documents and found no credible information, no information that could go to a court saying actions had taken place which would render the agreement invalid. And therefore, the two sides agreed that the Joint Commission, which had been configured and been authorized to receive evidence, documentation, critiques, and so forth from either party, that body sat and examined the information that came to it. But interestingly enough, the Venezuelan side, which makes great play amongst the, makes great play of the allegation by a jurist who was a member of the Venezuelan team. That information was not submitted for consideration by the Joint Commission. Now, you have fought to have this body established. You have urged that you be given a voice because apparently you found new information, and that new information has never been submitted. It isn't that they have not been providing the information left, right, and center to people that are really not of the court. Because you're in a situation where it is just allegations that are being made. And the substance, the so-called Malé-Prévost assertion that something untoward took place, has never been formalized so that it can be examined by a proper court. It certainly wasn't examined at that stage. When Venezuela had the opportunity to examine it or to have it examined by the court, the ICJ at the time, when they could have done, they didn't. And the question one has to ask, how serious is this contention? How strong is your evidence if you're afraid to share and submit it? So the failure of them to have this information submitted and examined left the two sides in a situation where they needed to ensure that one or other party didn't find or have an excuse for using force to deal with the matter. And therefore, as I say, the Geneva Agreement in Article 4 made provision for the two parties using the Office of the Secretary General, that's essentially what it is, to exhaust in some meaningful way the steps set out under the UN Charter. The UN Charter sets out how any of the international conflicts ought to be resolved, or major disagreements. They start with bilaterals by themselves, bilaterals with the assistance of the UN Secretary General. For example, in September 2015 to the beginning of 2016, the two parties were able to present whatever arguments they have before the Secretary General. And the Secretary General decided that there ought to be another year of good offices. And at the end of that year of good offices, of the good offices process, there was no resolution. And therefore, the SG wrote to the two sides saying, on the basis of what I have seen, this is what we're going to do. And I set that out before for you with the involvement of Mr. Doug Newlander. And the discussions had led to the SG concluding that many of those steps on the UN Charter had already either been exhausted or been made redundant. For example, you hear talk sometimes of Venezuela of arbitration. Who would agree to go to arbitration again when, having accepted the results of arbitration for 63 years, a country could have the temerity to simply call upon the world to abandon the outcome of that arbitral award? And so the SG and his legal department, together with Doug Newlander, looking at the options available, turned to one element that had not been tried and wasn't listed explicitly, but it did provide an opportunity for the two sides to work together with the assistance of the UN, and that was what was done up to 2017. And at the end of that period, the two sides were wider apart than they started. And this is significant. If you're saying two parties must discuss a matter, they either can discuss it between themselves or discuss it with a third party involved, and there are various options there. Or they will do it in a framework where a third party comes and makes recommendations or makes a set of proposals which may be perhaps put to the two parties, and they're required to act on them. All of those were available to the Secretary General, and all of those were available to the parties. Venezuela opted to go with where the Secretary General had suggested, namely the enhanced mediation, at the end of which the matter would be sent to the ICJ if the two parties couldn't agree, or if the two parties couldn't agree, if the difference between the two parties widened. And that is exactly what happens. It also went on to say that the SG since the two parties couldn't agree, the matter would be referred to the court, and that in essence is what happened. But the court, and just to show the safeguards, the court is required, where a contentious matter goes before them, to look at the positions of the two sides. And I'm trying to put these as simply as possible without trying to copy the language of the various agreements. And the court, for example, looked at some of the contentions made by Venezuela, namely that Venezuela never agreed that this matter could be sent to the court, that it never recognized the decision of 1899. And in a nutshell, the court dismissed those contentions as incorrect. That's the kindest that I could put it. And so the mechanisms set out under the Geneva Agreement have, to all practical purposes, been pursued and exhausted. And therefore, the matter of good offices was out of the purview of the SG and gone to a court, because what you're seeing, as I keep stressing, is after enhanced mediation, the gap between the countries was widening. The widening of that gap is dangerous to regional peace and security. And that is why the UN went in the direction that it did.
Now, we know that Venezuela was a party to the last ruling by the International Court of Justice.
Yes.
Now, did Venezuela accept the ruling?
The situation is this, that Venezuela was given the option to submit a memorial, not the option. It was required to submit a memorial by a deadline. Guyana was required to submit its memorial by a deadline. Guyana met the obligations by way of that deadline. And Venezuela had the option, under the rules of the court now, to challenge the memorial, and it did so within the deadline. I don't want to get into that, but there's some room there. But essentially, the court has decided, it submitted its preliminary objections in time, and the court entertained and considered its preliminary objections and acted on them. Okay, took a decision based on those preliminary objections, and it did not agree with Guyana that, for example, the deadline hadn't been met, and that it was exactly the same case as saying that the court didn't have jurisdiction. Those were rejected. But Guyana's argument in that line was rejected. But Venezuela's position on all the other matters, namely that the main defendant in this case should be the United Kingdom, because it was the United Kingdom that was involved in the 1899 arbitral award as one of the defendants, as it were. This was not accepted by the court. And the question you asked me as a non-lawyer, let me say this, that from the time, my understanding is from the time that Venezuela lodged the preliminary objection, they embraced the procedure. They asked the court to act on the basis of Venezuela seeking a decision of the court. And therefore, the court responded. Having decided that it had jurisdiction, it responded by considering Venezuela's preliminary objections and giving a decision on the various elements of the preliminary objections. One element of that, or a section of that objection was upheld. Sorry, a section of Venezuela's objection, yes, was upheld, but the remainder was not. And therefore, I don't think that in the normal course of events, Venezuela is in a position to say, well, I don't accept the jurisdiction of the court anymore.
Okay. Now, Venezuela seems to be flouting international law all the time with this border dispute, failing to recognize the ICJ ruling and so forth. So what is the next step for Guyana?
Well, the next step in the court is determined by the actions of Venezuela. We are in a situation where the court has given Venezuela time to, extra time in fact, to submit its preliminary, its response to Guyana's memorial. And they have until March of next year to do so. In the meantime, of course, we have work to do, try and anticipate what arguments they will raise, check evidence, follow what is taking place. And of course, Venezuela is making sure we are busy by doing a whole variety of, taking a whole variety of steps and actions, complaining to the court, alleging that we are doing A or that we are keeping bad faith, and the like. So the team is caught up in doing these other things whilst preparing for Venezuela's memorial, and at the same time trying to make sure that our case in responding, because we are able to refute after Venezuela makes the presentation of their memorial, we are able to respond and to refute anything inaccurate that they submit. So that's Guyana's next step. I suspect that you might be asking a wider question, and I would say this to you, that the process we are involved in began, in a sense, with a diplomatic and political process. That is in 2015, with the Secretary General of the UN calling the two sides together and deciding that this is a legal issue. You can't simply, as Venezuela has been trying to do, simply determine that a legal decision is null and void and then you act on it. Okay, so it was set off, or that action set off a political and diplomatic process in which they tried to resolve the matter without going to the court. Having gone to the court, there will be other elements of the process, which other elements will require, of course, that Guyana keep alert diplomatically and politically to ensure that the court's decisions are honored by both sides. Okay, so that is what lies ahead of us.
Okay.
We have to do our work now in the court. We have to do work afterwards to protect our interests.
Yeah, but Venezuela seems not to be respecting the ruling of the court, though.
Well,
I don't over the years.
I don't know that I would word Venezuela's behavior quite in the definitive way that you have. It is not unusual for parties to a dispute where one party's basic position is in any case in almost in defiance of the law, and in this case in defiance of international law. It is not unusual for them to test the waters. The preliminary objection was quite legal. It is their right to say, we think that the legal process has not been fully honored. And so they tested that and the court rejected it. The two parties to the Geneva Agreement signed that agreement for the peaceful resolution of the controversy. And the onus is on Venezuela to ensure that in whatever action it takes as a result of being unhappy with the court, that action is consistent with its obligations on international law. It isn't Britain now who signed that agreement. It doesn't matter that Britain signs that agreement. It matters that Venezuela signed the agreement. And the actions on the high seas in terms of trying to seize vessels, in trying to put illegal markers in Guyana's territory, it matters that Venezuela, as a signatory to an international agreement to which there have been other partners, that it honors those obligations. Otherwise, we will be within our rights to call upon the international community to note Venezuela's deviant behavior in this way and to call for action.
Okay. Now, Mr. Greenidge, you of all persons know more than most of us about the border dispute over the years and Venezuela threats over the last, 25, 30 years. But recently, Venezuela has made more threats because telling Guyana, the government of Guyana, that they should not give us any oil blocks because the matter is in court. So in other words, they want to stifle Guyana's development process, which President Ali has refuted. Now, do you think Venezuela would ever carry out its threats and invade Guyana?
Well, I wouldn't want to speculate on that, but I would say to you that Venezuela is already facing international sanctions for flouting international law and international agreements. And one would have thought that the Venezuelan populace and the Venezuelan government would be cognizant of that and not want to bring more burdens on the people of Venezuela. So the problem may be simply one of intimidation or attempted to intimidate the court and to intimidate Guyana. It is for the court to deal with that. And of course, for the government of Guyana to ensure that it does not let its guard down in those circumstances, and that it continues to do the diplomatic work and the political work with its neighbors, with its immediate neighbors, with its friends and its distant friends, and in the international bodies. I think sometimes when you are aware that the matter is before the court, if the government isn't making an announcement to the effect that a court, Judge A or Judge B was meeting somewhere today, or the agent is meeting with the court, people tend to think that nothing is happening, and somehow Venezuela can do what it likes. This is not the case. The court doesn't work like a municipal court. It spends quite a long time on these cases because they're complicated. And therefore, you have to give it time. But the court will also be aware that these long lapses between the initial complaint, or not these, but long lapses between the initial complaint and a court decision will not necessarily be helpful. I'm sure the court bears that in mind and tries to work as expeditiously as possible. And, you know, Venezuela will try to make room for itself as far as is possible. But the reality is that their hands are tied. None of these things is going to cause the court to just precipitately give a decision in favor of Venezuela or less favorable to Venezuela because Venezuela is trying to intimidate the court in Guyana.
Okay. Now, you know, next year there will be elections in Venezuela, and the opposition is campaigning on the fact that if they are elected government, the first priority is to get back the land that Guyana has or seized, which they claim is Venezuela's territory, which is 2/3 of Guyana's territory right now. Maduro back is to the wall, and he's making all these claims that he wants this and he wants that. But do you think Guyana stands a better chance with the opposition, who is strongly opposed to Maduro's way, the way he's fighting to get the territory back? The opposition is saying they will go and seize it militarily. This is the campaign that they're using over there in Venezuela.
Well, let me say, first of all, let me just remind you, the Essequibo, in the estimation of both Guyana and Venezuela, is about 166,000. The area is about 74% of Guyana's land surface.
Right.
Not 2/3.
Okay.
So it is far more than Venezuela likes people to believe. Secondly, the idea that the opposition will do something more effective than the government is common to almost all opposition movements.
True.
The purpose of any opposition is to always show that the government is either inefficient or is misguided, and that we as the opposition could do better. So I am not particularly concerned that the opposition is taking this line. And in fact, it has always been the case that the main parties in opposition now, who have been in government in the past in Venezuela, have been amongst the most militant and were in office when Ankoko was seized. The island of Ankoko, which Venezuela now occupies in its entirety, was one of the pieces of territory that the 1899 award tribunal awarded to Guyana. Half of that island of Ankoko, and Venezuela thought that they could do that, and they did it. It is now something that the court will have to look at. We have asked the court to pay attention to that, because that is not something that happened after 1966. The other issue of the seizure of territory is that we, again, as I say, have to keep alert. We have to talk to all those who are in a position to listen, including Venezuela's opposition, that there is a cost, there will be a cost to trying to evade the responsibilities as a state which is a member of the United Nations. And in those circumstances, they would be unwise to try and seize territory, which, and the point I was going to make before when I hesitated about the area, is that practically none of the area that we call Essequibo has ever been occupied by Venezuela as an independent state. None of it was controlled by Spain, even when Spain was the imperial power in these parts, because their exercise of sovereignty was challenged by the Dutch, effectively challenged by the Dutch. And that is why Essequibo can be found to have place names that are non-Spanish, non-Castilian, French, where the Essequibo, the so-called Essequibo rebellion took place, is a place with a French name. It is not a place with a Spanish name. In the heart of the territory of Essequibo, if you look at people's names also, you will find that the names of the populace, along with the names of the places, do not reflect any Spanish colonization. And so, in a way, if this weren't such a serious and sad case, it would be a joke that you are arguing that this territory had been yours for how many hundreds of years. You controlled it and it was stolen by you by another power. And there is no sign of consequence of Spanish presence in this area. And it is not a question of Britain seizing territory from Spain. It is a fact that what Britain took over in 1814 was territory effectively controlled by the Netherlands.
Mm-hmm. Yeah.
And in the interim, you had short periods. Now, French presence in this country is very short, and yet you have more French names, both in the Essequibo, La Belle Alliance, or La Belle Alliance, for example, where, which is one of the places in which you see on Venezuelan maps, people are hustling to, some Spanish speakers are hustling to replace. This is territory controlled by the British. The rebellions of the slaves did not take place against Spanish. The Spanish were not there. Right. The rebellion was against the English. People were deported to Australia. They were not deported, or they were not sanctioned by Spanish or Venezuelan authorities. Okay? As a matter of fact, at that time, Venezuela was itself in the throes of confusion. Wars between themselves and Spain, wars between themselves and Colombia, Peru, and so forth. So it is a rather bizarre claim if you look at the facts. And most people that you speak of who come across this matter for the first time find it very puzzling. But it is something arising from a dream rather from any realistic colonization of the area.
Mr. Greenidge, President Maduro recently promised to call a referendum on the border dispute. so that the people can have a say whether they should go ahead and annex the territory they claim to be theirs or not. Now, if that referendum succeeds, what significance this referendum will have on the border controversy, do you think?
Well, I find it interesting that you should say that the referendum would authorize the government to annex territory. I believe the international laws and the same laws that caused the UN to criticize Russia for what is taking place in Ukraine. The same laws say that you can't wake up a morning and expand territory by military force on grounds that you have the military force. So by the same token, Venezuela is not in a position to use a referendum as a pretext for annexing the territory of another country. It is not. The referendum and what Venezuela does internally is Venezuela's business. If it wants to hold a referendum to say that, Cayenne or some part of Demerara has another name, that's Venezuela's business. It can't enforce that in Guyana, and it cannot enforce it internationally. That it is not legal. It is like the decrees that President Maduro has seen it fit to pass as regards the maritime zone. Those decrees only have a standing, or only have legal standing within Venezuela. And Venezuela itself has argued, for example, that the US passes the domestic legislation and tries to make it extraterritorial. That is an argument that Venezuela has legitimately raised as regards a number of issues. And yet it is doing exactly the same and trying to give effect to those internal decisions by telling the international community, telling neighbors, and telling Guyana, well, we've decided that this is Venezuelan territory. But you may pass any legislation that your constitution allows. You may pass it. But the legal standing of that legislation outside of your borders cannot be unilaterally enforced in another state. And that's the fact.
Okay, let me ask you this question, and this is a presumptuous question, actually. Now, for the last 4 decades, the UN has offered the good offices for Guyana and Venezuela to meet and settle the dispute. Now, our listeners are saying why they could not have settled it in the good offices, and what is the good offices, what it means, what the concept of the good office. Can you explain to our listeners what it is?
When the Venezuelans announced in 1962 that they were going to they were going to revoke, as it were, the agreement that had been handed down in 1899. The diplomats tried to find a way to enable a resolution of the problem without it leading to any consequences of a nature that countries would regret. And amongst the avenues they explored was the use of, as I say, various mechanisms known to the international community. Now, the good offices process, actually, if you look at the Geneva Agreement itself, you may be puzzled. The good offices process is one in which, when the two sides couldn't agree, they spent a lot of time trying to choose a trigger mechanism or an honest broker that could put in place the next step. And that is specifically what the UN Secretary General's role is here. It said that if after the Joint Commission has met and the report from the technical committees submitted to the two governments is not accepted by them, the two governments can revert to the UN Secretary General, who would then choose the next means for resolving the controversy. And the means were, as I explained to you, taken from the UN Charter. The choice of the UN Secretary General, I believe, was Venezuela's. And the use of the Secretary General was accepted, or that role was accepted by the UN Secretary General at the time, Uthant. And the role is a little, perhaps, difficult to define with preciseness, in the sense that there is a breakdown as regards agreement on the next step. The SG will consult and he will move forward. But in fact, what happened initially, after the ending of the Joint Commission and so forth, was the appointment of an officer by the Secretary General after consulting with the two presidents, which officer was charged with, or which officers were charged with trying to help to find the way forward. Okay? And that mechanism that we have been calling good offices has those two elements. The Secretary General helping to choose the next step, and the Secretary General utilizing someone acceptable to both sides to explore avenues. And in a way, this could be seen as all sorts of things: confidence building, mediation of some kind, and after that, as itself didn't work, because that mechanism was one in which the two sides could make suggestions to these good officers appointed by the SG, and getting a feedback from the governments, he could decide whether there was any prospect of those suggestions being adopted by the other side. At the end of that very long process, the SG referred the two parties to a process he called enhanced mediation. Okay? Some people in writing includes the enhanced mediation of part of the good offices. Okay? Some people regard the good offices as having concluded in 2015, when Doug Newlander was appointed, and Doug Newlander worked with the two countries on this process that is called enhanced mediation.
Right.
I hope that is now clear. It isn't it's a term of art, really. Maybe the lawyers might have another view on this, but you know, lawyers, like economists, also stretch definitions and concepts, and this is partly what happened here.
Now, let me bring President Ali into this. He has the full support of the opposition because I think he briefed the opposition leader, Mr. Norton, on the Venezuelan recent claims. On the international scene, regional...
Well, it's not because he briefed them. He has the full support because the two parties, and let me make this point at the risk of upsetting people, the two sides agreed since 2015 that they had common ground and
Right.
they would support each other as the process moves forward. So it is not specific to President Ali. It is a process that has been going under the previous government,
Right.
and that is a fact.
But he was kind enough to brief the opposition despite what was going on between the two of them. Anyway, and
But
he
that's
got
another
support
matter.
of that's another matter. And he got the support of all Guyanese as well.
Yes.
Regionally and internationally, he has got the support of the United Nations and all pertinent international organizations, including our neighbors, CARICOM, and the Organization of American States, Organization of Latin American States, the OAS. Now, President Ali, I must say, did a brilliant job in briefing the UN of all what Venezuela is doing. Now, did you think what he did internationally, regionally, has muted or will deter Maduro from taking any further steps?
Well, I really wouldn't be so bold as to pronounce on Mr. President Maduro's boldness or brazenness. What I would say to both President Ali and to the opposition is that this exercise does not end with a speech. The work consists both of the preparations for the court, right? The dealing with the hearings as effectively as possible, and the political and diplomatic work that has to be done by the Ministry of Foreign Affairs and the ministers of the government and the Guyanese diplomats at home and abroad. It is not a one-point exercise where on the 20th of September, there is the court case and all the lawyers say all they have to say, and then that's finished and nothing else happens, and the court gives a decision. All along, the legwork involves both the preparation for the court and the diplomatic and political work, all the time, so that you don't have a decision, you don't have a situation in which Venezuela takes action, surprising Guyana, surprising the rest of the world, and then Guyana is busy trying to undo it. Because the undoing is where the problem will arise for Guyana. And therefore, it has to be alert, it has to be active, it has to miss no opportunity to speak to the international community through and at the multilateral institutions, multilateral fora, UN, OAS, African, Caribbean, and Pacific states, which constitute 79 states. It's bigger than the OAS, just incidentally. And its allies in the region now and those in the past, which includes Cuba, for example. Though that work has to be done, it has to continue to be done. You have to speak even to Russia, as we have done in the past. That has to continue. It is a continuous process. And the performance at the UN is just one element of a bigger show or a bigger program. And you have also to find new ways to alert and to work with your partners, including CARICOM. Because whilst we are sitting here saying, well, the president has done a great job at the UN, and it's not a criticism what you say, it's the reality that Caribbean leaders are being entertained in Venezuela. And the question is whether the diplomats of Guyana have worked with those Caribbean, not only the leaders, but with the Caribbean diplomats, so that the dossiers which brief the presidents or the prime ministers when the prime minister goes to visit Caracas is up to date and complete, so that there are no slip-ups. That is the issue.
Okay. Now, President Ali has got his support from the United States, the most powerful country on earth, they say. He has got his support from South America's military and economic powerhouse, Brazil. He has got his support from the CARICOM, as I said, the Organization of American States, the Commonwealth of Nations. But no one from the Arab League of Nations came out and said anything, or the Organization of African Unity, or the European Union. I have seen where President Maduro is making overtures to its OPEC member states, asking them for the support. Up to yesterday, I think the vice president of Venezuela was in one of those Arab countries. Do you think, as you said, we need to do more to bring all these organizations on board? The European Union, the African states, the Arab League of Nations, and everyone else?
Well, the simple answer to that is yes.
As well as Russia and China. They have not said anything about the border dispute.
Well, you see, the thing is that you have to speak to and coax and work with everyone. Everyone. That is the simple answer. As regards the countries that you named, this means that you can't say, well, OAS says something, so I don't have to go and speak to Peru. You can't say that OAS says something, so I don't have to bother with Bolivia. You have to be talking to them all the time. And as regards the states of the Middle East, which you mentioned, or the Gulf states, you know, they have been here. The representatives of some of those states have been here. We have an embassy in the UAE and in Kuwait, and ambassadors have a task in those countries. And this is part of the thing that we must understand. Fixing this problem and maintaining awareness in these countries is not simply a president-to-president matter. You speak to the country at as many levels as possible, whether it is universities, trade unions, but most importantly, at the diplomatic and technical level. This is as important. Not every place operates like Guyana, where you feel once the president has said something, nobody else has anything else to say. Presidents are briefed in other countries. They are briefed, okay? And there are times when presidents opt to go in direction A, and the technical briefing is such that they have to revisit those decisions. Not what we have to do is to make sure that we work with these potential or actual allies at these levels, so that the briefing that informs the decisions by the heads of states and the heads of government are decisions which take into account Guyana's interest. And Guyana's interest in almost all these instances is consistent with those of these countries. Many of them are small states. They may be well off in the case of the Middle East. They may be well off, but most of them are tiny. And they have an interest in balanced decision-making in the international community and not being bullied by and railroaded by large states. The African Union is also such a region where you have large states physically, but most of them, if not all of them, are weak in the context of the international community where it comes to decision-making. Their voices in the places where numbers don't matter, their voices are relatively weak, and therefore you have to talk to them and brief them. The European Union is a case simply because of the way it makes decisions, and I think many people believe perhaps that Spain is likely to oppose a Guyana interest in the European Union. I don't think that is the case. So you have to do your work. You have to work on the European Union representatives. You have to talk to the Commission. You have to speak to the individual member states continuously. Continuously. They have an interest in Guyana. They have an interest in Guyana's stability. They have an interest in Guyana's continued existence. And if they have an interest in Guyana's continued existence because it now is at the margin an important or potentially important addition to oil production, then they have to listen to the problems and challenges that you have and to ward off and use their influence to ward off factors that will lead to instability. The same thing applies to China. China has a state-run entity operating in Guyana. It is part of the petroleum and oil sector, and it must have an interest in Guyana's stability, notwithstanding its interest in Venezuela. But China is not a country that would normally voice support publicly where a controversy is involved, and you have to live with that. You have to live with that. But that doesn't mean you go and ignore them and assume that they must know where the mutual interests lie, and therefore you don't have to say anything to them. You have to keep working with them, find common ground, exchange ideas, work with their universities, and this has to happen notwithstanding positions that the U.S. takes, because the U.S. alone, first of all, the U.S. looks after its own interests. Where it needs to go to China to speak to the Chinese president, it does so. That's what is happening right now. You have to be able to do the same thing. And that's why you have to speak to everybody.
I got a question from one of our listeners, and let me ask it to you. I don't know if it's the right question, but I'm going to ask it anyway.
All right.
The person asked me to ask you, isn't it your responsibility to brief the diplomats in these various countries? And they said, have you briefed the Chinese diplomats in Guyana or the Russian diplomats in Guyana?
Well, the question actually shows that the questioner doesn't fully understand how the executive works. I am, and my title is Agent to the International Court of Justice.
Yeah.
Okay? And that is working with the teams that prepare the material for the case and looking at things Venezuela does and seeing what implications they have or can have for the case. The responsibility for briefing diplomats on in the international arena, briefing our own diplomats, is split. So, for example, the briefing of the diplomats of Guyana has been done from time to time by me, but the issue is for these diplomats to work with their partners, whether it is in Brazil or in Burkina Faso, and the instructions to them and the monitoring of their activities is that of the Minister of Foreign Affairs. The Ministry of Foreign Affairs is the institution that works on that aspect of our work. It isn't even the Office of the President, which sometimes we seem to get confused about. The diplomats operating out of any country, the diplomatic corps, for unity of purpose and consistency of policy, work out of and on the basis of instructions by the Ministry of Foreign Affairs. That is their work. The ministry works with them, the president appoints them, okay? And the ministry gives them briefs and ensures that one ambassador knows what the other one is doing. He may be doing something in Peru about briefing of Venezuela, but he may have another assignment from the ministry, and the ministry is supposed to ensure that they don't have crossed lines or conflicts of interest, well, not conflicts of interest in a personal sense, but they understand the priorities and concerns of the country. So it is not my responsibility. I was going to say, I'm pleased to inform you, it's not my responsibility to do those things that you have outlined. The country has to make sure it's done, but there is an institution that has responsibility, and sometimes we do get, as your question reveals, exposes, we do get our lines crossed. The advice I give is to be given to the President, Ministry of Foreign Affairs, on matters when you see matters touching on the court case with Venezuela, advisor on borders, and anything to do with the court case. It is my responsibility to receive and pass on information and to help to coordinate analyses and decisions from the advisory committee, which specifically works on the court matter.
But
I hope that helps.
it helps. But my question to you is this: the diplomats in the Ministry of Foreign Affairs, do you think they have the pertinent information so as to brief all the diplomats in other countries as you do?
Well, some of these diplomats that are still with the ministry or might have left them recently are professional diplomats, and they have worked on this and other matters for far longer than I have. I happen to have done, let me say this, I'm not blowing my own trumpet. I'm an economist by discipline.
Right.
But in the course of being an economist, I have ended up negotiating many agreements. You will remember the annual wage agreements in Guyana. Each time the question of wages were to be negotiated, I ended up as the minister responsible. And outside of that, within the European Union, the negotiations between Guyana and the European Union involved negotiations. And in that forum, I ended up representing ACP countries, 79 ACP states, and dealing with the European Union on commodity prices and all sorts of things. So I happen to carry some experience and skills in negotiations per se. But within this ministry, we have had over the years some of the finest diplomats in the Caribbean working on the Venezuela issue, working on bilateral issues, working on multilateral issues at the UN. I can learn these as we go along, but I am not, and I should not be regarded as the expert in these areas. And in time, or in the past, well, let me just point you to Rashley Jackson, the late Rashley Jackson, one of our finest diplomats ever. And of course, you have Sri Ramphal, who is still on this exercise, who has worked far longer than anyone else on the Guyana-Venezuela controversy, because he was with it. He was with it at the time when the matter was raised by Venezuela in 1962. Just to give you an idea. So my own involvement has arisen because I think it was thought I bring some special skills to this rather than being the foreign affairs expert. This is an arena where many experts can be found. We don't use all of them, but the fact is that elsewhere, including in Venezuela, the expertise of Guyana is recognized and accepted. And I would add that one of the reasons why the two political parties should be seen to be embracing the challenges, refuting the attempts by Venezuela to unfairly gain our territory, arises because it is important that in such a small state we maximize all the skills. That's how I would put it.
True. Now, have you advised the Minister of Foreign Affairs to get his diplomats to brief all these diplomats in various countries?
I think that the administration may be tired of hearing me talk about this. I've, on your own program, said this several times.
Okay.
So I've said it ad nauseum. Of course, a government is a government. They don't always pay attention to what you tell them. And it is not that I'm a minister. So my function is to advise. It's like taking a horse to water. You can only take the horse to water. But I believe that the government is aware and has accepted that people must be briefed. The question may arise in the end as to whether in practice sufficient is being done at any point in time in that regard. And I suppose any two people can disagree on whether sufficient is done or whether some more should have been done with Latin America or whether you're neglecting the African, Caribbean, and Pacific group of states. There's a lot more that could be done. We have in the past, I myself had in 2019 gone to you speak about the African Union. I had, with the encouragement and assistance of Ghana, gone to participate in an AU meeting and share some information with the African delegations. It wasn't done to the extent that it should have because for reasons to do with Guyana, we arrived late. And therefore that couldn't be joined. But we've worked on these things, even in Saudi Arabia, in the Latin America, Saudi Arabia conference, which takes place periodically, spoken in that forum, lobbied people in that forum, found common ground with Argentina, for example, just to give you an idea. You know, people, you know, when you are not a diplomat, and I'll say this, when you are not a diplomat, you may want to think, well, these people are not helpful. They're Latins or they are Spanish speakers or something, and therefore they won't be sympathetic to us. In diplomacy, my understanding, what I've learned from the diplomatic mafia of Guyana and elsewhere, that you leave no stone unturned. Even the people that you think you can't persuade, there's no harm in speaking to them, making sure you give them accurate information. Put it as favorably as you can to them. And you can get cooperation. So in 2017, you had a Latin American, Saudi and other Arab conference. And there was a resolution posing us some difficulty in that forum. And again, one of the things we learned at that time, not that we didn't know, but new government had to learn that you can't absent yourself from meetings. And when a summit takes place, expect to turn up at a summit and swing the whole summit your way. Some of the presidents can do it. But it depends on the caliber of the president. It depends on the issue itself. And so we did have that problem. And subsequently, we were able to collaborate with Argentina on this matter to a point where we could agree common language. We could find acceptable language to deal with problems that we shared.
Okay.
And that is the challenge that faces you. You have to do this thing continuously, not simply say, well, I talked to them last week, or a previous government spoke to them, and we don't have to do anything now. You have to do it all the time.
Okay. Now, with the exception of a few cases, and they're very small amount, history has shown that most border disputes have not been settled peacefully or by the ICJ ruling, but by wars.
Mm-hmm.
Do you think the ICJ or any other peaceful means could settle our border dispute?
I do.
Wow.
You ask a question which I believe can be answered in as briefly as that. First of all, let me say additionally again, that I do not believe that how disputes have been settled in the past is relevant here. Disputes were settled. There was a dispute between Haiti and France.
Right. Well,
In the 19th century, no,
Right.
not arising from its independence, but in the 19th century, where a Frenchman tried to disembark at a Haitian port, and he was unhappy with how he was treated. And the next thing you knew is that France, instead of any other option, decided to threaten the country by sending warships and demanding all sorts of payments and so forth. But that is a fact that none of us can dispute. It happened, but it doesn't mean it is relevant to the year 2023. The extent to which there has been criticism of countries that have sought to solve their problems by military means gives an indication. In the 1920s, the UN had passed a resolution formally forbidding countries from trying to change their borders by the use of force. As regards the effectiveness of non-force means, we don't know. I mean, I can't tell you that 2% of conflicts have been solved without force, but of course, there are less wars today over borders than they were in the 20th century, let alone in the 17th and 18th centuries, and we have to bear that in mind. Today, the world accepts that when a problem arises, especially of borders, you must try and find and use the diplomatic means. And I would draw your attention even to Latin America here, where countries had decided that they did not agree with the arbitrary decisions that had been taken, even of the ICJ. And in the end, those did not all end up in wars. They haven't all ended up in wars, and some of them are in the process of being resolved. Nigeria and Cameroon was one, perhaps, of the most famous cases of not only of a border dispute, but where one party decided in very, very unequivocal terms that it would not accept a UN decision which required that it cede territory that it was regarded as its own. And we are here in 2023 with Nigeria, for example, accepting and agreeing to live by the bulk of that decision, which it had rejected very, very harshly in not even 50 years ago. Okay? So one has to one has to bear that in mind. The effectiveness of the international court depends on many factors. Some of them have to do with the nature of the claims, whether they are historically valid or not, and a number of other things. For Guyana, okay. I think we've had a very, very good case, and Venezuela will have a difficulty sustaining its argument beyond a formal court decision.
Okay, I agree with you. I don't think Venezuela will ever invade Guyana because they will know the consequences will be very, very grave. We've come to the end of the program. It was a very fruitful discussion. I learned a lot, and I hope our listeners did as well. So, in that said, I'll ask you to give a closing statement.
Well, Dr. Rose, I thank you for your patience, because I know sometimes in giving these answers, I can be long. My students sometimes draw that to my attention, even my colleagues. But this is a complicated case. True. And I take the liberty of going long rather than short, because sometimes if you can break the thing down simply, it is better for your audience, so that that they can more clearly understand what the issues are and where our options lie. So thank you for giving me that opportunity. And I hope that your audience shares the very generous sentiments that you expressed about the utility of the comments. So thanks ever so much, and to your technician for rendering assistance on this matter. Thank you and take care.
Thank you very much. And I hope our listeners enjoy the program. And one thing I take away from the program is that we need our diplomats to spread out, to convince the other diplomats in various countries about the issue. The more information is being spread out on behalf of Guyana, it's better. Thank you very much, Mr. Greenidge, and it's a pleasure having you here tonight. On behalf of